Hi, everyone. We have some major breaking news. We just wrapped our show, and of course, we received the big news of the day. The Supreme Court has now ruled 9-0 to reject the Colorado Supreme Court decision that would have held Donald J. Trump off of the ballot in that state. The Colorado Supreme Court affirming a Colorado Secretary of State decision ruling that Donald Trump was not allowed on the ballot because he had violated the 14th Amendment in their estimation. The 9-0 decision is a bit complicated, Krystal, and we can break it down for everyone. Let's put it up there on the screen. While they unanimously agree that the Colorado Supreme Court went too far and the Colorado Secretary of State in their disqualification of Donald Trump on the ballot, the majority opinion, which includes 6 out of the 9 justices, effectively says that this was overstepping the role of Congress, that Congress, through its enumeration of the 14th Amendment, not only had to have that stand, but would have to pass a piece of legislation that specifically lays out which individuals and how were to be disqualified from office under the 14th Amendment. 3 of the liberal justices, Ketanji Brown Jackson, Justice Sotomayor, and Justice Elena Kagan, dissented from that majority opinion, but found with the 9-0 unanimous decision that Colorado had gone beyond the terms of the 14th Amendment. So basically, the majority opinion and where this justification now comes down is Colorado went too far, and that in the future, that Congress itself must pass specifically which types of individuals, why and how are disqualified from the ballot, and that the hodgepodge nature of allowing secretaries of state like Maine or Colorado and others could not stand. That's what they all unanimously found. So very impactful case, probably the most significant one since Bush versus Gore in terms of that decision, but this one a little bit different in its finding. For its number.
It wasn't surprising, the direction that this went in. Just to emphasize one of the things you're saying there, that piece about the majority ruled that Congress basically has to pass a law in order for this section of the Constitution to apply. My recollection from when I was researching this previously is that would mean that this provision is not self-executing. Some parts of the Constitution just, they are what they are, and they are, available for enforcement as they are, and others actually require an act of Congress. That's what the majority is saying. That's the piece that a minority of the liberal justices are saying, hey, we don't agree with that part. That part goes further than we need to in this decision. Just as a reminder, I want to read to people the text of Amendment 14, Section 3, just so we have a recollection of what we're talking about here. So it says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. That last piece, the fact that it points in the amendment to Congress, was part of what they used as a justification for saying, well, that sort of indicates that what they really mean is Congress has the final say in how this provision is applied. One other thing that I wanted to note here is that they do not appear to have taken any stand or said anything about whether or not they believed that Donald Trump engaged in an insurrection or gave aid or comfort to an insurrection. And that was not actually even the focus of his team's argument in this case. They were focused more on these technical legal questions. Does the President of the United States count as a, quote, officer of the United States, or as an office holder of the United States? Who does this responsibility fall to? And I wanted to read a little bit of the liberals who had the dissenting view that they agreed that Colorado went too far. They agreed that they did not have the power to enforce this particular piece of the Constitution. But they said they should have had a more limited ruling. They say if it is not necessary to decide more to dispose of a case, then it is necessary not to decide more. That's from actually the Dobbs decision. That fundamental principle of judicial restraint is practically as old as our republic. This court is authorized to say what the law is only because those who apply a rule to particular cases must of necessity expound and interpret that rule. That's Marbury versus Madison. Today, the court departs from that vital principle, deciding not just this case, but challenges that might arise in the future. In this case, the court must decide whether Colorado may keep a presidential candidate off the ballot on the ground that he is an oath-breaking insurrectionist and thus disqualified from holding federal office under Section 3 of the 14th Amendment. Allowing Colorado to do so would, we agree, create a chaotic state-by-state patchwork at odds with our nation's federalism principles. That is enough to resolve this case, yet the majority goes further. And again, they go on to point out this piece of their interpretation that the body that has the ability to enforce this provision is Congress. That's the piece that they dissent on, even as they agree overall.
Yeah, it's actually interesting, too. Trump's argument, as I'm understanding here from what they write, was to hold that the Section 3 disqualifies, quote, every oath-breaking insurrectionist, except, as they write, the most powerful one, because he was arguing that the president was not, in effect, a quote-unquote office holder of the United States. He says, actually, though, both of these results are inconsistent, both Colorado and President Trump's argument about the highest office in the land. Thus, they then use the contextual point to Congress and say both of the Trump argument and Colorado argument are inconsistent with the historical basis of Section 3 of the 14th Amendment, and thus they're establishing this new standard for how this is going to work in the first place. So I know it's kind of complicated, legalese and all that. The net effect is obvious. It's Colorado lost. Maine and all these other states are not allowed to do this. I guess it invites an interesting question, because one of the things that we had talked here before is if they had ruled in the way that the liberals had wanted to them, then this would have been a different question post the conviction if it were to happen of January 6th on that case, because there's going to be a big argument there on a legal standard about free speech. But Supreme Court now making it so that even if any of that were to occur, Congress itself by 2/3 would have to pass a law being like, yeah, that qualifies as an explicit event under X, Y, and Z, and that's how you are able to remove somebody from the ballot. So this is one setting a pretty high standard, effectively politically impossible today, but who knows what it would look like in the future, that we as a Congress and the people are the only ones who will be able to establish some sort of law where states could act in this manner.
After anyway. Biden mania sweeps the nation and they've got a 70-seat majority in the Senate and a majority in the House, they can pass this law deeming that Donald Trump is an insurrectionist. Just to underscore or give an example there, so if they had ruled in the more limited way that the liberal justices wanted them to, and basically lived unresolved. Okay, they're saying Colorado can't do this, but we're not going to really say what the process would be that would meet our standards. Then if you had someone like Trump who was actually found guilty of insurrection through the criminal system, then you could have an argument again of like, okay, well, now does this apply? The Supreme Court, first of all, Donald Trump has not been charged with insurrection. I just want to be clear about this. I'm just talking in hypotheticals here. But the Supreme Court has closed that door and said, no, this has to be explicitly done through congressional legislation. But as I said, not making any sort of determination of whether or not, in their view, Donald Trump did incite or aid or abet, whatever the language is, an insurrection. So that's where we are.
Just a reminder, too, there's still quite a few cases for Trump before the Supreme Court. We still have the immunity case where we heard some of the arguments around there. That wasn't really expected today. This one, I believe, had to have an expedited opinion in order to resolve this before the election. And there may even be some more that come to the court. So all of that will affect the overall trial date for the eventual January 6th trial. So stay tuned. This is not the first breaking news segment that we're likely to do on the subject. We will see you guys later.
Hey guys, if you like that video, go to breakingpoints.com, become a premium subscriber, and help us build the best independent media organization on the planet.
That's right. We're subscriber funded. We're building something new. We want to replace these failing mainstream media organizations.
So again, to subscribe, it's breakingpoints.com.